Good afternoon, everyone. I think we should start in the interest of time. The others will join us as we go on. Welcome to today's session. I'd like to welcome everyone who has joined us for this session. My name is Leonora Arua, a program officer at LSK Nairobi branch. We'll start off by, I'd like to give my apologies from the chair. She had a personal matter to attend to. I'd like to welcome everybody to this session. This is the third in the series on pension practice. The branch endeavors to enlighten members of opportunities that lie in the different areas of practice, away from the traditional areas known to most. Most people consider pension only as a means of saving for their retirement and not as a possible area of their legal practice, yet there are many opportunities that lie therein. I'd like also to thank you all once again for attending, and I'd like to introduce our speaker for today. Our speaker for today is Stella Musemi Ojango. She is a partner at Gikera and Vadgama Advocates and head of the Nairobi office. She has a distinguished track record in delivering advice on real estate projects. This includes advice on property acquisition, obtaining requisite approvals, securing development, financing, preparation of contract documents, registration, and handover of development. She has expertise in property law, Kenyan data protection law, employment and pension law, as well as personal law. She has trained and advised various organizations on data protection, prepared and reviewed data protection policy, issued legal advisory on retirement benefits related to issues to several corporate entities in the private and public sector, including listed companies. On her education, she has a Bachelor of Law degree from Moi University and a diploma from the Kenya School of Law. She is currently pursuing her master's degree in environmental law and has also undertaken the Trustee Development Training Program. She is a member of the Law Society of Kenya and an advocate of the High Court of Kenya, and a council member of the Association of Retirement Benefit Schemes. On her hobbies, she is passionate about the environment and she loves the outdoors. The discipline of systems, running to prepare one's body, exercising and keeping to the track are a translation of the same in her work life. In her spare time, she loves reading motivational books and spending time with the family. Thank you so much, Stella, for being our speaker for today. I'd like to welcome you to begin the webinar for today. Karibu sana, Stella.
Thank you very much. I hope you can hear me loud and clear.
Yes, we can.
Thank you very much, Arwa, for that introduction. As mentioned, I am Stella Musemi Ojango. I'm a partner within the Gikera and Vadgama Advocates. As Arwa also mentioned, we've had a three-part series. So this is the third part, talking about opportunities in pension law. My seniors who went before me, that is David Nyakundi and Calvin Nyachoti, did take us through opportunities for lawyers in pension. I want to digress a bit and look at a specific facet under pension or trust laws. And in specific, I want to look at the incorporation and the Trustees Perpetual Succession Act. So this is a fairly old act. It's an act of 1932. That's how far back this act goes, how that impacts on others practitioners, what are the opportunities within this act. That's what we'll be looking at today. So without further ado, we will be looking at a few objectives for this particular training. We'll be looking at the concept of a trust. We need to explain that and demystify that. What is a trust? And then further to that, the Trustees Perpetual Succession Act was recently amended as 2021. So we will look at those particular amendments of that act. Then we will look at key features prior to amendment. So what did the act say prior to amendment in 2021, and why did we need to amend certain sections within that act in 2021 December? Then what are some of the major regulatory changes consequent to the amendment? what is the process of incorporation of a trust? Because we're looking at incorporation of trust. So what is that process? What does that entail? And then once you're incorporated, why would you even bother to be incorporated? Why would you even recommend it to the client? What are the benefits of incorporation? Then we'll look at a few case law and then a few takeaways for us, even as we finish this particular training. So in a diagrammatic fashion, a trust is a concept. It is set up by a sponsor or a settler, otherwise also known as a founder. So the term founder is correct, the term sponsor is correct, the term settler is correct. The term settler is used much more in family trusts. The term sponsor and founder is used much more in pension scheme, provident fund kind of trusts. But that term is to mean the same. The person who sets up a trust can either be a sponsor, either referred to as a sponsor, a settler, or the founder of the trust. So this settler who sets up this trust, the first thing that he does is that he appoints trustees. I know we know of trustees as individuals, but the law in Kenya does also foresee corporate trustees. So when you talk of trustees, it can be either individual trustees, that is you and I, or it can be a corporate entity registered under the Companies Act, and for purpose of pension or retirement benefits act, registered with the RBA. So for corporate trustees in Kenya, they are registered under two laws, the Companies Act and subsequently under the Retirement Benefits Act. So you can have, those are the two types of trustees that exist, individual trustees and corporate trustees. Once the settler sets up a trust and appoints trustees, he's definitely setting up this trust for the benefit of his beneficiaries. So he goes along to list his beneficiaries. If it is set up by, say, a pension scheme or a provident fund, then the scheme will indicate in its trust deed who qualifies to be a member of the fund. We call it eligibility. So who's eligible to be a member of the fund? So that is clearly stipulated in the trust document. The amendments that I mentioned earlier of 2021 did introduce a new office, and that is the office of the person known as an enforcer. We did not have this before. In other jurisdictions, the enforcer is also known as a protector. So we will look deeper into that and what that means and what is their role. But we have that extra person who's now added to trusts. So the founder sets up the trust. The founder transfers certain assets to the trust as provided in their trust deed and rules or as provided in their constitution, because trusts can also have constitution as their form of document that describes what they do on a day-to-day. So the assets to be transferred are clearly provided in the trust deed and rules or in the constitution of that particular trust. And then the trustee's sole responsibility is a fiduciary role, a common law doctrine of fiduciary responsibility. So they have a fiduciary responsibility to manage the trusts, to manage the assets of the trust in a responsible manner for the benefit of the beneficiaries. And now we will look at what the enforcer does while checking what the trustees are doing. So that is what a trust is in a nutshell. So we are saying this Act of 1932 was amended in 2021, but not to say that it has not been amended over the years. It has been amended severally over the years, resting with this amendment of 7th December 2021, which was gazetted through a special issue of the Kenya Gazette, number 229 on the 9th of December, and it came into force on the 23rd of December 2021. So as of 23rd December 2021, there are certain salient amendments to this act that I would like to draw to your attention and that are very beneficial to a practitioner like you and I, or to a person who's looking to set up a trust, or to a pension scheme that already has a scheme that is set up but is not incorporated, and why that should be drawn to their attention is important. So I need to give you a bit of a backdrop of what the Act provided prior to the amendment. So the Act prior to the amendment of 2021 provided that trustees who are set up or who have been appointed to manage a body or an association of persons established for a religious purpose, so that is our churches, educational purpose, that's our schools, literary purpose, scientific purpose, social, athletic, or charitable purpose, can seek to be incorporated under this act. So the act had limited it to such persons or to such bodies of association: a religious, a church, a school, literary, scientific, social, athletic, or charitable purpose. The act also provided that trustees of a pension fund or provident fund can also may apply to the minister to be issued a certificate of incorporation. So that means under that act, prior to amendment, only these entities could be incorporated under the act. So the other addition to that, over and above these entities, that the minister had discretion upon application by a party and having regard to the extent and nature and objects of the circumstances of the trust, consider incorporation expedient. So that means the minister could incorporate other entities at his discretion if he found the nature and objects of the trust to be of import, to be expedient. So he would, at his discretion, allow other bodies to be registered over and above the ones listed. And this is section 3 of the act as was then. Currently, still section 3. As this is as per section 3 of the act. So the minister also had discretion to add any other body over and above these ones listed here. So the changes that came in 2021 brought in a few good aspects. Number one, they introduced the aspect of and the right of a family trust being registered under the act, and that is being incorporated under the act. So this family trust can be set up for charitable or non-charitable purpose. If we look at the previous provisions of the act, it only seemed to appreciate charitable. Now the act has gone on to appreciate that a trust can also be set up for non-charitable purpose. This family trust can be set up jointly, probably by 2 people, probably a husband and a wife, or it can be set up by a single individual. And the purpose, of course, of setting up this family trust is to manage the personal estate of the settler who's setting up the trust. So the main reason why these acts, why these amendments, so the need to introduce family trust as a matter of right to be incorporated under the act, was for the preservation and creation of wealth for multiple generations. As we all know, most of our clients come to us and we prepare wills for them. And what happens that an estate that is probably 5 million or 10 million, once it is bequeathed in the will, then the beneficiaries of the will share out the estate. And that estate now is 5 million divided 5 times or 6 times, depending on the number of beneficiaries. But now in setting up a trust, that wealth is preserved in the trust for the benefit of the beneficiaries. So a family trust in its very nature under the act should be a non-trading entity. And of course, it is set up for beneficiaries, whether such beneficiaries are related to the settler or not. So the settler can list other people who are not related to him as beneficiaries in the trust, and whether those beneficiaries are living or not. So you can, the settler can set up a trust and indicate beneficiaries to be his great-grandchildren, who are probably not born at the time he's setting up the trust. Can also be a posthumous child, a child who's still in the mother's, one of the wife's tummies. One of the wife will be expectant. So he cannot name the child because the child does not have a name at that point. As much as life begins at conception, this child does not have a name. It's a posthumous child. So the trust can be set up for beneficiaries, whether related or unrelated to the settler, whether living or not. So that you then say, my first great-grandchild to go to Harvard or to make this achievement should get this part of my estate. So that then they aspire to achieve certain things that you've put for them in the trust. The other thing is that now the act, the amendments that came in 2021 now recognize non-charitable trusts. Non-charitable trusts may be created for a specific purpose, notwithstanding the absence of any beneficiary. So this is a very unique form of a trust, because it will not ideally take the format of how a trust would look like, because it does not necessarily need to have a beneficiary as per the law. And then And then this non-charitable trust should be set up for a specific purpose, capable of fulfillment, and that is not illegal. So this purpose creation must be for a specific purpose. That purpose should be capable of fulfillment, and the trust should not be set up for illegal purposes. And then, of course, the trust deed should provide for disposition of surplus assets upon determination of the trust. So you'll find such a trust will not probably be one in perpetuity, an irrevocable one. It will be one that probably has been set up for 70, 30, 40, 50, for a specific time, for a specific purpose, which purpose is capable of fulfillment, and the trust deed itself provides for disposition of surplus assets upon determination of the trust. I did earlier mention that the amendments to the Act did introduce the office of an enforcer, otherwise known as a protector in other jurisdictions. And the role of the enforcer, so the enforcer can actually be the settler himself. The settler can actually be settler come enforcer. Or it can be any other person, body or association of persons who is appointed or replaced by the settler and the beneficiaries in the absence of the settler. So let's say the settler has passed on, the beneficiaries can replace an enforcer, or they can appoint one if one was not appointed. And the sole purpose of this enforcer is to monitor the administration of the trust for the benefit of the beneficiaries. So trusts are administered, or they are run by trustees. So what the enforcer does is that he checks on what the trustees are doing. So that means the enforcer is not a beneficiary. The enforcer is not a trustee, because you cannot check yourself. That's conflict of interest. So the enforcer it can be the settler or any other person, provided they're not the beneficiary or the trustees. And their role is to monitor what the trustees are doing and whether they're doing it to the benefit of the beneficiaries. Another major change that came in through the Act was the transfer of the minister's functions to the principal registrar. And this is the minister in charge of lands, currently known as cabinet secretaries. So the Act had previously provided that if you wish to be incorporated, you then apply to the minister in charge of the Ministry of Lands at the time. But then these amendments have changed these. So the application is made to the principal registrar and not the minister. And this has some very good positive effects, because ministers in their very nature are very busy running the ministry, running aspects of coming up even with regulations, different things that they have a role of doing. So requiring them to sign a certificate of incorporation really takes them from their day to day. And that's why you will find these certificates will take so long. Previously, I have clients who took 2 to 3 years to incorporate trust. So, and it was a deterrent thing. The Act had made it somewhat deterrent because of how long it was taking. So now that role has been moved to the principal registrar. The principal registrar is now mandated to approve or disapprove applications for incorporation of a trust under the Trustees Perpetual Succession Act. So this change, what it does is that it makes the process of registration or incorporation less hectic. And of course, it's achievable in realistic timelines. The Act has gone ahead to provide a specific statutory timeline for approval or rejection of applications. The Act now provides for 60 days from the date of submission or receipt of an application by the principal registrar. So once the principal registrar has received an application, they have 60 days to approve or disapprove the same. So this makes the timelines very, very, very effective for processing or incorporation of trusts. So what is then this process of incorporation of a trust? What does that entail? And since we are advocates, I think this will be of great importance to us. So a client has come to you, they want to set up a trust, or they even have an existing trust, they wish to have it incorporated. What is the process? So it's a twofold process. Firstly, it starts with the trust deed and rules of the fund, or the constitution of the organization, if it is a school, if it is a church, that constitution or that TDR should be stamped. Of course, the stamp duty is nominal, and then subsequently registered with the Registrar of Documents under the Registration of Documents Act. So this for sure does not take long. I know RDA is one efficient registry, does not take long at all. So once that TDR or constitution has been registered with under the RDA, second thing is that now you, as the advocate or as the organization that is looking to be incorporated, you petition the principal registrar to be incorporated under the Trustees Perpetual Succession Act, so that the body corporate, the board of trustees that is then incorporated, and what is incorporated is a board of trustees. And the certificate that you get says fund registered trustees. So it is a board of trustees that gets incorporated in the name of that entity. So that body corporate now has capacity to manage its affairs and own its property by virtue of incorporation. So that's the second process. And the second process requires a few things. So that petition that you then prepare and submit to the principal registrar should be, one, accompanied with the stamped TDR or constitution of the association. It should secondly be accompanied by a resolution appointing the trustees. Because if it's a school, the officials, who are these officials? What is the document that appointed these officials? That document that shows who the list of officials are. For a pension scheme, it is the trustees. For an individual trust set up by a settler, it is the trustees appointed by the settler. So that document that shows who the trustees are, the current trustees of that entity are, should accompany the petition. Then you will need a diagrammatic representation of the common seal. And this is a seal that will be used by the incorporated entity upon incorporation. So this diagrammatic representation is just like our standard seals for companies. So this diagrammatic representation will be appended as an annexure to the petition. And it will indicate trust at the center, registered trustees, because what is getting registered is a board of trustees. So that diagrammatic representation will be an annexure to the petition. Then you need copies of title document as proof that the fund or association is in possession of removable property. So I know there are certain associations that are not in possession of removable property. And what we have done for such associations is that we have indicated in the petition that they intend to acquire property in future. But the very nature of this act is that it presumes that you want to be incorporated for purpose of owning property or that you already own property. So a copy of the title as proof that the association owns property. Then we'll require the evidence of the financial status of the entity. So copies of bank statement or financial statements of that entity are required. Then a brief summary of the trust. Why was this trust set up? Why did the settler set up this trust? How many years has it been in existence? What are the source of finances? And remember, a settler can prepare a trust deed under the Trustees Act. And that will be a trust for all intents and purposes. If he now wishes to incorporate it, then that trust deed is what he will come up with and what he will annex to the petition. And over and above that, he will briefly give a summary of why the trust was set up, how many years it has been in existence, and what is the source of finances for this particular trust. And then, of course, there's a statutory application form that accompanies the petition and all these documents that I've listed here. As it comes to the trustees, trustees have a fiduciary responsibility. They're the ones running this trust on a day-to-day. So we require, the principal registrar requires a curriculum vitae of the trustees, a resume, just a one-page document. As far as I'm concerned, of course, it can be many pages if you want to put more information. But most importantly, it has to say that you're a trustee of dash and dash, a trust, or trustee of dash and dash association. A copy of the trustee's ID and KRA PIN, the trustee's postal address, their residential address, what they do on a day-to-day when they're not trustees, and colored passport size photos. In the event the trust is being run by a corporate trustees, registered under the Companies Act and the Retirement Benefits Act, the corporate trustee, which is a company, has directors. So the directors will be required to give these documents in their personal capacity as directors of the corporate trustee. So what are some of the benefits of incorporation? Why should we bother getting incorporated? Why? And why should we even recommend this? So number one, which are these entities that are required to be incorporated? As far as I'm concerned, these are entities that are registered under majorly the Societies Act. We all know that the Societies Act does not make a body registered under that act a body corporate. So a school, a church, an athletic organization is not a body corporate. It has a certificate of registration under the Societies Act, but it's not a body corporate. So it is important for such entities registered under the Societies Act to consider incorporation, especially if they want to own property, especially if they want to distance the trustees and the entity, so that the entity becomes a legal person. Of course, the entities registered under the Retirement Benefits Act also do not become body corporates, so they need to be registered under this particular act. Trusts established under the Trustees Act of 1929 do not become body corporates. That trust that you establish under that act does not become a body corporate. So if you want to make it a body corporate, you incorporate it under this act. So that incorporation gives you the power to sue and be sued in the name of the incorporated entity as opposed to the individual names of the trustees. It gives the incorporated entity the power to hold property, of course, including land, in the name of that fund or association, as opposed to the individual names of trustees. And the challenge with this is that we put names of, say, a church, we put the names of the officials in the title. Officials come and go, officials pass on. We find it so complicated for this church or for this school to dispose that property, because that property is owned in the name, in the individual names of the trustees, or if in the case of a school or a church, officials of that society. So it is important that such entities are incorporated to put that distance between the individuals, and for perpetuity purpose, for ease of transacting when those individual trustees cannot be traced. Then power to transfer, assign, charge any movable or removable property in the name of that registered incorporated association, as opposed to the name of the trustees. And then, of course, ease of execution of scheme documents or trust documents. It becomes very easy, because now what you will do is you will append the seal that you have given a diagrammatic representation. You now prepare a seal, you make a seal, you get a seal for that incorporated entity. The incorporated entity executes through the seal, which seal is witnessed by trustees as per resolution of the Board of Trustees. So the Board of Trustees can pass a resolution, or should pass a resolution, indicating who are the trustees to witness this seal. And so that even when those trustees are not around, all you need to do is to pass another resolution to say, now the following trustees shall witness the seal. And the seal is the way by which that entity that is incorporated will be officially and legally signing documents. And then, of course, ease of registration of funds and associations with the Office of the Data Protection Commissioner as data controllers and data processors. So you find some of these organizations, an example of pension schemes. So by law, a pension scheme can have a minimum of 4 to 9 trustees. So you can imagine if these trustees want to be registered as data controllers, it becomes very hectic to register 9 people on the certificate of registration issued by the OTPC, or even to register 9 people on a title document. So once you're incorporated, it is that incorporated entity that gets now registered as a data controller and a data processor under this particular act. Even that goes for school, and that goes for churches that are run by officials. So what are some of the statutory obligations upon incorporation? Because everyone wants to know, yes, you're pushing for me to get incorporated, and these are the merits. What are some of the other concerns or statutory obligations I should be aware of? There's only one statutory obligation upon incorporation, and that is a requirement to file annual returns with the principal registrar by the trustees of that incorporated entity, indicating the names and address of the trustees. Remember, we have said the trustees are the ones who are witnessing the seal. So the principal registrar at any time annually should know who are the current trustees of this scheme. Whenever there's a change of trustees, it is prudent to file those returns. And in any event, annually, we're supposed to file returns with the Principal Registrar Ministry of Lands, indicating who the current trustees of the scheme, what are their names, and what are their addresses. So this is one of a statutory obligation that had always been there. It has not been introduced by the amendment, but I think this is the only obligation. And I think this obligation in its very self, the benefits outweigh this one statutory obligation, which should not be a hindrance to us recommending incorporation of trusts under the Trustees Perpetual Succession Act. So I said that we would look at a few case law. I have listed about 2 cases. And this one is for a trust set up by an individual. And this is it's a reported case, the Njenga Karume Trust. The case, I believe, was finalized in 2015. So what the settler did here, and that is Njenga Karume, he set up the trust in his lifetime. And that's the good thing about a trust as opposed to a will. You know, a will only comes into force when the testator has passed on. A trust, on the other hand, comes into force when set up during the lifetime of the settler, the founder, or the sponsor. So that's a very major advantage, probably that I didn't mention in the advantages, that you can set up the trust in your lifetime. Then this particular settler appointed 5 individual trustees. We've said that there's also the option of appointing a corporate trustee. Then he listed the beneficiaries of the trust, his trust in the deed. He did list who the beneficiaries should be. Then the settler set up 3 holding companies through which the trust owned assets. Remember, we earlier said that the trust is not a trading, it's a non-trading entity. So that means for purposes of trading the assets of the trust, it's important to do it through a multifaceted approach, like he did in this case. He set up holding companies that will trade, but then these holding companies would ideally be owned by the trust. The trustees of this trust incorporated the trust under the Trustees Perpetual Succession Act. So in this case, the settler did not incorporate it in his lifetime, but the trustees subsequently incorporated. They were allowed to incorporate under the trust deed that the settler had constituted for this trust, and they incorporated the trust for purpose of the trust owning property directly. Then plaintiffs, you know, this is a case. So the plaintiffs deemed the role of the founder's advocate to be that of an arbiter and custodian of the trust, akin to the role of an enforcer. So in this particular case, though the trust was set up years back before this amendment of 2021, the settler was very forward-seeing. He had actually appointed a firm of advocates who the plaintiffs deemed to be arbiters and custodians of the trust. And their role was actually, as far as the plaintiffs were concerned, to oversee what the trustees were doing. The settler had also given the advocates the power to change or replace any trustees for whatever reason. So this case started in 2015. The judgment was rendered in May of 2020. That's about 5 years. The plaintiffs were seeking to have the trust wound up by the court. Those are the orders they were seeking. But then the court said that it is not the duty of the court to uphold, it is the duty of the court to uphold and protect trusts, not to destroy them. So that means the courts are very keen to ensure that trusts live out their full potential. It is a function of the court to execute a trust, to see that the trustees do their duty, and to protect them if they do it, and to direct them if they are in doubt, and if they do wrong, to penalize them. So that means the court has a role, even in ensuring the trustees do their bit. And the court gave orders for the appointment and replacement of some of the trustees in accordance to the founder's wishes. That is through his advocates, as indicated in the trust deed. The court found that the remedy was not in dissolution of the trust, but rather, and to give the control to the beneficiaries, since this would defeat the founder's intention. So trusts are not likely to be dissolved. The court will be keen to ensure that the founder's intention lives through what the founder intended it to be. Let's look at another case, and this one is the estate of the late Mbiu Koinange. This case started in 1981. The judgment was rendered in 2020. And this is what the court had to say. Of course, amongst other things that the court said, is that one wishes that all Kenyans can get into the habit of planning their lives, and especially thinking about what will happen to their families and properties upon their death. It is not too much to ask that the planning be by way of writing wills. And I would add, be by way of setting up trusts. So the effect of this case taking so long in court is that there was wastage of the assets. Some of the claimants and some of the plaintiffs passed on during the pendency of this case in court. So as I conclude, I would like us to look at what is our takeaway from this training. So we are saying registration, stroke formation of a trust under the Retirement Benefits Act, the Societies Act, sorry, there's a typo there, or the Trustees Act, Cap 167 of 1929, does not confer corporate status to a fund, an association, or a trust. Therefore, incorporation of boards of trustees is key under the Trustees Perpetual Succession Act for an entity to be a body corporate. An individual can also set up a family trust and have the same incorporated under the Act, since now the Act expressly provides for this. And in the days of the estate of the trust of Njeka Karume, it was actually set up by discretion of the minister. We saw that the law previously provided the minister discretion to allow any other form of trust to be set up. So that's how it was formed. But now we have an express provision for family trust, specifically to ensure that the wealth of an estate is maintained for generations and for posterity. Thank you very much. That is my presentation. Ira, back to you.
Thank you so much for the insightful presentation, Stella. I want to welcome the members, open the floor up for any questions. Please, you can raise your hand or you can type it in the chat section. Any question from today's webinar? Kindly raise your hand or put it in the chat section. Members, the floor is open. You can raise your questions. Yes, Jacqueline, you can go on.
Thank you so much, Leonora. I just want to appreciate Stella, who has taken us through a very, very informative presentation. And just for purposes of reference, I don't know if Stella, you'd be so kind as to share with us your slides. Sometimes it's good for us to refresh our minds every so often when we're dealing with a matter.
Okay, not a problem. I should be able to share through the LSK branch, Nairobi, and then they should be able to circulate to their attendees.
Thank you very much.
Any other question from the participants in the meeting? Okay. There being no other question, I'd like to appreciate Stella. Thank you so much once again for making time for us. We truly appreciate for the insights you've shared with us. And we'd like to ask you to come again, share with us once again for the insights. We will never get tired of learning from each other. Thank you once again, Stella. And thank you for the participants who have joined us for today's session. Please watch out for our next sessions. Thank you so much to everyone.
Thank you and most welcome. Bye, everyone.
Bye, everyone. Everyone can live at their own pleasure. Thank you so much, Stella.